Welcome everyone to lecture number 28.15, 28.15. So in this lecture we are going to see what exactly is present under the article number 26. Okay, this article 26 deals with the freedom to manage religious affairs. It deals with the freedom to manage religious affairs. Okay, it deals with the freedom to manage religious affairs. So what are the things present under it? So this article 26 guarantees the rights to all religious groups subjected to public order, morality and health. Okay, so what are the subjects and all that has been pointed here? So this article 26, it subject to, it is related to the subject to public order, morality and health. Morality and health. Okay, which is for every religious denomination, every religious denominations shall have the right okay, what are those rights? So first, the right that it is provided to them to establish and maintain institution for religious and charitable purpose. So anyone is free to establish and maintain institution for what? For religious, like ISKCON temple and all, we used to see religious and charitable purposes, and charitable purposes. Okay, now second thing, it is this right is given to manage, that the people can manage its own affairs let me, I'm getting one ping. In matters of religion. See, religion institutions are not barred to are not like they have to pay the taxes. If the whatever the money is collected and all, it's completely from the purpose of donation or religious purpose, it is not used for electoral mean and all, so in that case they are not liable to pay taxes. Okay, they are free to manage its own affairs in matters of religion. Now, to own and acquire, to own and acquire movable and immovable property. Movable and immovable like land and all, land, house and all. Immovable like temples and all. Okay, so to own and acquire movable and immovable properties. And the last one, to administer such property, in accordance with the law. Now, so what are the questions on that? the queries or overall conclusion that we can make with this article. The secular functions can be regulated by state, but not religious functions. Okay, that if it is related to the secular functions kind of things is there, so in that case state can regulate, but it is, if it is completely a religious function like how to do yag, and also in that case state can regulate. Now sometimes it's difficult to judge the category of the functions, like what kind of category is that. In that sometimes state used to be confused on that thing. Let us suppose if I am telling that feeding laddus to the idol in religious function, even though money is involved. So whether this thing, money and all this thing is involved, whether this thing we will be seeing as a secular stuff or religious stuff. Here the government used to be get confused. Let us suppose at what time it will be fed in completely religious practice, like at what time we want to fed to the idol and all, it is completely religious practice. But sometimes let us suppose a scenario that songs used to be played when these things happen, and a regulation is there after 11 p.m. no loud music or can be played at that time. So yes, in that scenario sometimes clash used to happen. Okay, so this was present under the article 26, that it allows that freedom to manage religious affairs. You are free to have your religious affairs. So that's all that we can conclude from this article 26. Now we'll see article 27. What does this tell? So article 27 tells that the state cannot compel the state cannot compel any citizen to pay any taxes, for the promotion or maintenance of any particular religion or religious institution. Religion or religious institutions. Okay, so it tells that, it overall signifies that the state cannot compel any religious institution or that you have to pay taxes to government. Whatever the collections you are going to make, they are not compelled to do so. So freedom as to payment of taxes for the promotion of any particular religion is there. No person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated for the promotion or maintenance, that is promotion or maintenance of any particular religion. If it is completely related to that, in that they are not bound to pay taxes. And secularism is the basic structure, so a state does not have a religion, so that taxes will go for Amarnath as well, for Hajj travelers as well. So let us suppose if like religious activity, whatever the earning is religious activity, they are not bound to pay taxes, but government can use our paid taxes money in various religious activity. Okay, but the government can use our taxes, like like as a general public we used to pay taxes to the government, right? But government can use and that paid taxes money and also in the various religious activity. Like we have seen that government used to provide security or multiple camps, and all things are placed over different types of yatra. Like in Amarnath yatra, government spends a lot every year, and whenever supports, government also support Hajj travelers. Okay, Hajj travelers also government supports and all. Okay, so yes, government can use them our money for religious functionaries. Okay, as why is it so? Because because secularism is one of the basic structure of our Indian constitution. Okay, now article 27 we have discussed. Now we'll wrap up this article 28. What is this article 28 tells? Article 28 tells that no religious institutions, no religious institutions can be provided no religious institutions can be provided in any educational institutes wholly maintained out of state funds. Wholly maintained out of state funds. Understood? Like no religious institution can be provided help completely through the fund of state. Okay, so it freedom as to attendance at the religious instruction or religious worship in certain educational institutions. So like what I'm trying to explain, that attendance to the religious institutions and all, their government state fund cannot be completely used, cannot be used for that. Okay, so now that it should not be wholly maintained by the state, that religious instruction can't be imported within the state functionaries. It should be there are 4 types of education institutions that are present. Let me explain you, then only you will be able to understand what exactly I'm trying to tell. So there are 4 educational institutes. Okay, what are they? First is wholly maintained by the state. Okay, one institution which is completely maintained by the state. Now second, that type of institution which is recognized by the state. Okay, which is recognized by the state. Here religious instruction can't be imported. Here religious instruction can be imparted but not compulsory. That religious instruction can be imparted but not compulsory. Okay, here it is not allowed at all. Now third one, receiving aid from the state. Okay, like they are getting support from the state and all. And fourth, established by the religious charitable trust and administered by the state. Okay, here religious instruction can be made and can be made compulsory also. Here religious instruction can be made and can be compulsory also. Okay, and what we are talking article 28, we are talking about in the article 28 about this institute which is wholly maintained by the state. Here we cannot use any religious instruction, okay, to run that. Understood? Now proceeding to that, we will see article 29 also. Article 29, what it tells. Article 29 clause 1, it comes with that where a religious community is in the minority, where the religious community is in minority, the constitution enables what it enables? Enables to preserve the culture, to preserve their culture, to preserve its culture and religious interests and religious interests by providing that the state shall not impose it any culture other than the community's own culture upon it, other than the community own culture. What do you understand by this statement? This statement tells that if you are a minority within a particular region, so a state can protect you from your culture from get law from get away what I am trying to tell, getting lost from this region. If your government can't protect that, it means that government can't impose any other religious activity on your over your religious cultures and all. Okay, so it tells that where the religion community is in minority, the constitution enables to preserve its culture and religious interest by providing that the state shall not impose it any culture other than their community's own culture. State cannot impose any culture on them if they are in a minority. If let us suppose within their culture men and women men and men can marry. Let's suppose it is a very tribal society where this kind of things is going to is happening. So government can't intervene with that. They are in minority area. They have get a protection and they can continue with such kind of activities. Government can't impose a uniform civil code kind of things upon them. Okay. Now there is protection of interest of minorities, and one more thing that when we are telling that it is minorities, this term minorities is not defined which are the things are will be contained under the minority. Like any section of the citizens residing in the territory of India or any part of there have a distinct language, script or culture of its own shall have the right to conserve for the same. So whatever thing, even if you are, if your cultural language is in minority, you speak different kind of language, you can be also called that into you can also be get protection under this article 29. Okay, this minority can be counted within the language, script. If you have different kind of a script, that will also be counted under it, or culture. If you have a complete different types of language, script, or culture that comes under the minority, yes, you will get the protection from the government. No citizen shall be denied admission into any educational institution, institution by the state, or receiving aid out of the state fund on ground only of the religion, race, caste, language, or any of them. Okay. Further, yes, asking vote on the name of religion will be disqualified. If the some person is asking vote on the case of religion and all, the person will be disqualified. But yes, asking vote on the language, script, or culture, yes, it is allowed. Okay, because to protect the diversity, you wanted to come up from this section of the society, or you want to create a welfare society for these kind of minority section, yes, you can do so. But if you ask a vote based on the religion, that is not allowed. Okay, so right to conserve the language of the citizen includes the right to agitate over the protection of the language. Okay, and this right under article 29(1) is whatever we have spoke. 29(1) is absolute. It is absolute. Okay, so this was all about in article 29. Now we'll see article 30 also. Let us we complete this whole section of this article, this fundamental right and all. We'll complete that. Okay, so article number 30. So whatever we spoke in article 29 regarding them only, this article 30 tells that. So what was the article 29? That where a religious community is in the minority, the constitution enables it to preserve the culture and religious interest by providing that a state shall not impose upon it any culture other than community's own culture. So it was talking about the religious minority, that a state cannot impose any other cultural aspects on to those minority section. They will be having their own culture. Okay, whatever this thing. So this right is given to those minority section. Okay. Now what article 30 tells? Article 30 tells that such community, that those religious minority that we have spoken about in article 29, so such community shall have the right to establish and administer educational institution of its own. Okay, they can have their own education institutions. So such community shall have the right, shall have the right to establish and administer, to establish and administer educational institutions of its choice. Educational institutions of its choice, like for as per their choice they can choose it. Okay, and state shall not in granting aid in educational institution, like state has to provide aid and all, like nobody is restricting a state in granting aid to such religious institutions. Like a state are not allowed to for any aid to the religious institutions and all. Like state can uh, like use their our taxes to for religious activity, but here it is like by the provision it is given that a state can aid to such stuff. So a state of its choice, and the state shall not in granting aid to educational institutions discriminate against such an educational institution maintained by a minority community on the ground that it is under the management of a religious community. What is true? Let's see. Such community, what type of community? Minority religious community. Okay. Now, such community shall have the right to establish and administer educational institutions of its choice, and the state shall not what? In granting aid, educational institution or discriminate against such as education institution maintained by minority community on the ground that it is under the management of religious community. So a state cannot tell that we can't grant you aid because you are from a religious community or this is your religious education and all. No, a state cannot do so. A state has to provide aid and all to those such minority section with respect to their educational institutions also. Okay, so this was present under the Article 30. Now Article 30 1 clause A also tells that the full compensation has to be paid if the state seeks to acquire the property of a minority educational institution. Now within this we have Article 30 clause subclause A. Article 30 clause 1 subclause A. Now what it tells that full compensation has to be paid if the state seeks to acquire and it should be for a larger public interest. Okay, the state seeks to acquire the property of a minority education institutions. Okay, so this Article 30 tells that that they have to receive aid and all for the education institution. And now Article 31 clause A tells that if government has acquired their land, so then they have to be compensated, fully compensated for whatever the land has been acquired by the state. And yes, that acquisition must be in the favor of larger public interest, then only this will be a valid thing. Now here is a catch, whatever the full compensation is going to be paid, it will always be a government price of the land. Okay, what actually is happening in India, like whenever the land is being sold, so the price of the government price is being not it is being paid every time there is some certain amount is being paid, and taxes has been used to pay as per the government whatever the prices has been fixed for that region. Okay, so that is the thing that is going in India, that is illegal, but yes, but it is going, and tax is being tax is not being paid to the government through this mean of selling of land and all. Okay, so now so this Article 30 clause 1 provide the right to property for the minority section, as per there in there is article 31 that was lead to that was, there is a story behind that, so we'll see what exactly that is story. If you see article 31 clause A, we are talking about right to property. Okay, there were already one in article 31 we had right to property, but now it has been deleted. This fundamental right has been deleted. Okay, now but still this fundamental right exists for minority section through how we in 30 clause 1a we have seen. Okay, so fundamental right for minorities for the right to property is there. Now doctrine of eminent domain, something is a concept, it is a concept where government can acquire piece of land for larger interest of people, even it can acquire the land of property of which section, minority education institution section, but compensation must be provided. This is this is called as a, this concept that you have to pay that tax, and that government has to compensate whatever the land is being seized and all. This is something, this concept is called as a doctrine of eminent domain. Okay, and whatever the price is will be paid, it will be as the market based only. Okay, now in St. Stephen versus University of Delhi 1991, Supreme Court said that minorities educational institutions should reserve 50% of their seat of their own community. In St. Stephen versus University of Delhi 1991 case, here Supreme Court said that 50% of the seats of such minority education institution can reserve it for their own community. If it is a minority education institution, so they can reserve up to 50% of the seat for their own community. Regarding that, TMA Pi versus State of Karnataka, there was one case where the minority education institution can have their own admission process or criteria, but this has to be reasonable. So there was another case that we should remember, TMA Pi versus, I guess that's TMA Pi is the founder and all of, I guess, Manipal University. Please check for that. I guess that he was that one. So TMA Pi versus State of Karnataka. So here it was told that minorities education institution can have their own admission admission process, okay, or criteria. Now but the question but whatever the criteria or you whatever the process you will mention, it must be reasonable. It should not be like something else out of the world. It should not be like that you said like, even if you fail I will take the admission. No, that cannot be the case. Okay, yes, you can reduce the percentage of that. You can increase, like 50% reservation is there for your minority criteria section, but if you want to increase that, yes, you can do so. It is up to you. So you can change the admission process and all, but whatever thing, like even if you want to increase this percentage, it must be reasonable. Okay, so further they can have their own fee structure. But no capitation fee. It means like no donation. Donation must be there. Donation should not be there. Must not be there. Donation, no donation. Otherwise it is like illegal, corruption is going on. Okay, so this was all about in article 30. We don't have article 31. Article 31 has been removed. but Article 31, that right to property, is given to minority education institution, and Article 31 was removed in a 44th Constitutional Amendment Act. Okay, so this was all about in this lecture. Thank you. So we have discussed till Article 31, that we were discussing about Article 31. Now we'll quickly complete that Article 32. What is this Article 32? Okay, and after that our fundamental right section will be completed. Okay, after fundamental right section will be completed. Like we'll see, there are few more sections, like Article 34 also deals with that. Article 35 is present under that, so we'll see what are the things. We will complete those aspects quickly here. So Article 32, it tells about the constitutional remedies. It tells about the constitutional remedies. Okay, so the fundamental rights are guaranteed by the Constitution not only against the action of executive, but also it is against the action of legislature. Even let us suppose if police has arrested you illegally, the constitutional rules will be applied to them. Even if legislature within the parliament wrong law has been passed, that here also fundamental right will be guaranteed. If it is violating a fundamental right, the law will be shut down. Okay, so right to constitutional remedy, which was termed as this constitutional remedies was termed as the soul of the constitution. It is called as the soul of the constitution. It was soul by the constitution, by whom? By none other than Dr. B.R. Ambedkar ji. Okay, so earlier without right to life, no enjoyment of fundamental right was there. So like right to life was various of a times it was being improvised by the court, also being suggested by the court, like these things are also, many things were added into that. So earlier without right to life, no enjoyment of fundamental right was there. Even if you don't have a right to life, so what was the need of fundamental right? You are not going to enjoy that. So even if fundamental right does not have a remedies, then also all the fundamental right is useless. Similarly, if there is no remedies, let us suppose someone is violating your fundamental right and you don't have a remedies for that, then what is the use of that fundamental right? Okay, right, it means like the fundamental right with nothing but it just a guideline kind of things. So that's why this fundamental right constitutional remedy Article 32 is very important, and that's why it is called as the soul of the constitution. Okay, so even if the fundamental right have a remedies, then also all the fundamental right is useless. Even it doesn't have a constitutional remedy, then fundamental right become useless. So it will be the only paperized if no remedies is there. What I'm telling that it will be only a kind of a guidelines if no remedy such kind of thing is given in the constitution. So B.R. Ambedkar said that Article 32 is the most important fundamental right, without which whole constitution would be nothing. Okay. And Article 33 deals with the power of parliament to modify the rights conferred by this part in their application to forces. So it deals with the constitutional like power of parliament and their modification, that they can do the rights, that is given through the Article 33. And Article 34 tells the restriction on the right conferred by this part while the martial law is in force in any area. So Article 34 tells that in India, if there is a martial law has been implemented in the country, then all the fundamental right will be your shut down. Okay, till now this hasn't been done in the India. Till now this hasn't been occurred. And now article in martial law, what happened? In martial law, regular government gets shut down, and military took up the power of the country. Okay, and if we tell Article 35 legislation, this it tells that the legislation to give effect to the provision of this part can be done through the legislative used to change the laws and all, right? They used to pass also legislation to give effect to the provision of this part, what? Fundamental right part 3. Okay, like Article 35 tells that legislature can make changes or make a provision within the fundamental right, but it should be the basic structure of the constitution, and it could not be at any case be non-reasonable. Okay. And Article 33, it gave the power to modify the parliament to right conferred by this part in their application to the forces. Okay. So Article 33, it allows the parliament to modify any right if it is required, and then also make into the implementation, make into the force. Okay. So Article 33 gives the power, Article 33 gives the power to parliament. Article 35 gives the power to the legislature, and Article 34 tells that your fundamental right can be snatched during the martial law. That's it. This was all about present under the fundamental rights. Even after that, if you have any doubt, please put your comment over this over the video. I will be happy to reply over there. Even though if you are not feeling good over there, you can directly connect with me on my social media handle with questions. I will be happy to help for you that. This is a new channel. I really need your support. Please subscribe this channel. Thank you.